0000650, styled in the matter of the marriage of Latoya Bell Zarate and Anuart Zarate Martinez, and in the interest of their children. But they do have some limitations in others, and one of those, I am told, is that it's particularly difficult for the court reporter. She's not in the room with us. She can't see us quite as well as she could otherwise, and we have a tendency to sometimes talk over each other. So I'm going to ask you all to please do your best to fully enunciate your words, to do them in a way that allows the record to be compared and treated as best.
I'm sorry, Judge.
Matters that are set
Judge,
a motion to enter judgment.
Judge,
I'm sorry.
You're breaking up some.
Yes.
You're kind of frozen.
Yes.
It's breaking up.
Yes.
Can you hear us?
Oh, I'm sorry, because you're all, I can hear you. I don't know whether I can restart or something.
You're breaking up a whole lot. And kind of freezing periodically. You were real clear earlier when you first got on, but then I don't know if you want to go out and come back in.
I just tried to reboot my router. Is it still a problem here?
Not right this minute.
Yeah, some of y'all are frozen, looks like. All right, to my understanding, what we're going to be doing, and we have only an hour in which to do it due to a medical appointment that is scheduled on my end. We're going to be taking up a motion in judge that we had, or the trial that we had, and we're also going to discuss a motion for new trial that was filed by the petitioner's attorney after the trial was completed.
I'm sorry, Judge, you're still breaking up for me.
Okay.
It's me. I apologize to interrupt again, but it's very glitchy.
Yeah. Let me see what I can do here. I don't know if I leave the meeting and come back, if that's likely to do anything, or if I can even do that.
Pam, you're on mute.
It sometimes helps if you sign off and then just come back in. I mean, we've had people do that before and it helped.
All right, I'll try to leave and I'll try to return then.
Okay.
Okay. How are we doing at this point? Good.
Good so far.
So far, good. So far, so good.
You haven't said a whole lot though.
Okay, I apologize. I'm sorry. I don't know much about technology. What I was about to say, or what I did say, is I've got a 10 o'clock medical appointment, so we've got to get to the seminal issues and get this resolved. Quickly.
Judge, you're breaking up again. I'm so sorry.
In the interest while giving for me, I saw Jen. Well, let's hope the third time, if this is the third time, is the charm. All right. What I have said, and maybe been heard, maybe not, is that I have a 10 o'clock appointment, medical, that it will require us to complete this hearing by then. And so we're going to focus keenly on the issues, which are the motion to enter the judgment that I rendered some weeks back. We're going to discuss, to some extent, a motion for new trial that has been filed. I take all of this from the perspective of the best interest of the children. That is the primary obligation. That is my major objective here. And without being preachy, I will say that it's my experience that children need the cooperation and the guidance and the examples that are set by the adults in their world, which means the parents here. We had a 2-day trial at which I was the fact finder, following the rules of procedure, the rules of evidence, and exercising my judgment and discretion as to what was credible. Mine went away for a little bit, but we're at the stage where we are needing to get the rulings of the court committed to paper, signed, and filed with the clerk. They were to be followed as soon as they were pronounced, but we do need the written record. And so I know that Ms. Marglione has drafted a proposed judgment decree that she believes reflects my rulings. I know that Ms. Eggleston came into the case after the trial and is in the very difficult position of trying to make sure that things reflect. But I know also that both lawyers have submitted some drafts, which also indicated that there were some negotiations or some discussions going on to see whether they could reach agreements. And so I'm starting from the point that if there are things that are outside the scope of what I specifically ruled, those would probably not be in the judgment. And so, Ms. Marglione, you're, or maybe Ms. Eggleston, I'm not sure who feels that they are in a better position to tell me these things need to be in, these things need to be out. Again, I start from the position that Ms. Marglione, as the prevailing party representative, would have done what she could to properly reflect it. And Ms. Eggleston, perhaps there's something that you are thinking, well, if I'd had a chance to get into this case earlier, we could have negotiated these terms, or since the judge has ruled, we can negotiate these terms. So tell me, please, quickly and directly, what needs to be in the decree that are the respective decrees from your perspectives, Ms. Marglione.
Yeah. So you have inbox, and we emailed you the track changes version that is in there. And then this morning I put in a clean version of what I have requested. But basically the track changes version has basically it was my version, which Miss Eggleston made some changes to. We made some changes, and then if she wanted to delete some of mine, I left it as, my language is deleted, but put a comment for what was my comments on it, like why I feel this is needed and that kind of thing. Ultimately, there's quite a few items to go through. And I kind of think we probably need to just kind of plug our way through the order. But ultimately, yeah, I mean, I think that's where we're at. I mean, basically it's just differences in understandings and what needs to be included versus what doesn't need to be included, that kind of thing.
Ms. Eggleston, does that approach make sense to you? Are you suggesting or agreeing that that's a good way to approach this?
I think so, Judge. I think that Josie and I did a good job trying to work together and come to agreements on what we could. And we've got a final redlined order that I think makes most sense to just run through.
Well, I have limited technology, as I've already explained, and we've experienced. I have not seen those recent documents, and I don't know that I can see them. I don't know that I have access to Box. Should have it. I don't have it. And so the things that you sent recently, I have not run off, printed up, or reviewed, but perhaps we go one by one. This provision is in contention, and let me make a ruling on whether it is or is not in a particular parlance, and then go to the next, and then go to the next.
Happy
I was just I'm sorry to interrupt. I don't know if you want to get them maybe to share screen where you could look at it, just an idea.
That's a very good idea. Thank you.
I was about to suggest it. I can share screen. I have it up, and I can share screen with everybody.
Great. Thank you.
You bet. Okay, so should I just go ahead and address them as we go? Plug away. All right, so I had a provision in here for the findings just basically addressing the fact that there were accusations of family violence, and then also basically some suggestions of violations of the standing order, and basically you addressed those and said that, so basically I'm just putting in here findings that those are denied.
Ms. Eggleston, your position on that?
It's Eggleston, Judge. Thank you.
Okay.
When taking a look at the transcript, the language that you used was that you're not persuaded sufficiently to make those positive findings. I don't know that that would result in an insufficient evidence finding in the decree.
Two things occur to me, and you all have thought this through probably. One, what if we just leave that totally unspoken?
My proposal, Judge, was
if it's not specifically granted in the decree by inference. And is there a pushback or a problem with just deleting it entirely?
Judge, you're breaking up again.
Yeah.
Judge, if I understood correctly, it was whether or not it should just then be removed and not addressed in the decree. That would be my proposal.
And you're saying that there's an inference that since it wasn't granted. And I guess my only issue is that because she didn't specifically plead for family violence, but she made arguments during the trial, that was the reason that I wanted to include that part. That was my only.
It seems to me that if it is silent, then that relief was never granted, whether it was requested or not requested. It's just not in the case. It's not in the decree.
Okay. All right. So we will just remove that section then. Okay, come on. Okay. And I'll try and do some cleanup later, but in the interest of time, I want to try and. Okay. Then we get to the rights and duties, and you stated that Mr. Zarate was granted, so basically he was granting managing conservator, and that he had exclusive rights. And so they wanted to delete the child support part, but there's reimbursement. There's no official child support, but we have reimbursement for medical, health insurance expenses, and 50-50 split on various expenses for the children. So I believe that it's important to leave that in there.
Ms. Eggleston?
The only reason I deleted the word exclusive in the beginning sentence is because each line below it says exclusive, and it was just duplicative. It doesn't really have any impact on the order one way or the other. As far as number 4 is concerned, this is actually for child support payments, and that's not what was ordered. Neither party was ordered to pay support, so neither party gets to receive child support payments. There's language in the order about extracurriculars and medical support, but not child support.
And my argument is medical support is child support.
Give me just a moment. Well, I don't have total recall, and I don't know that I specifically said anything about child support in my oral pronouncements. And so if what we're talking about is that if this provision number 4 is eliminated,
Judge, you froze.
I'm sorry if we ought to reconvene this on another day, or at a later hour because of that it's 9:30 and we're just barely getting started here. Pam, are you able to hear me?
Yeah, you froze briefly. We have hearings at 2:00, but we could do it. I don't know what your schedule is today. Or tomorrow, we don't have any hearings in our court if tomorrow would work better.
Well, obviously the lawyers and the clients may have some things as well, but let me look at my calendar and find it. This afternoon is clear.
No, we have hearings at 2:00 for probably a couple hours.
And then tomorrow,
We don't have any hearings all day tomorrow.
tomorrow I have something at 3 p.m., but nothing in the morning.
I have a conflict in the morning at 10.
And then Thursday, I am clear.
We have hearings all day Thursday.
And Friday, I am clear.
And we have hearings Friday morning. I'm out of town, so I have a sub, but we've got hearings in the mornings, at least part of the morning, but
So of the times of the dates that are available on this three-legged stool, which actually guess is a four-legged chair now that I include my staff, my temporary staff in here. Does that look like tomorrow afternoon or this afternoon?
well, we have something at 2, unless y'all wanted to meet at, I don't know, at 1. If we'd have to start our other hearings or by Zoom at 2, so.
I could do one this afternoon.
And what about the rest of the week?
Tomorrow really would be
Con-
the only, I think you said you had something at 3:00 tomorrow, but maybe at 1:00 tomorrow. I don't know if the parties are available.
I'm set in Williamson County tomorrow.
Okay.
Judge, do we want to maybe try turning the video off and seeing if that would help? If you just have your audio, perhaps.
Well, I turned my video off, but I'm seeing and hearing you all, but you're apparently not
That's close.
hearing me.
We are. That sounds
can hear
good,
you.
actually.
Yeah.
Yeah, we can
Okay.
hear
Perhaps we
you.
should try that if we have enough time.
Yeah, we can see how much headway we can make, and then if we have to, reconvene tomorrow tomorrow, I think I heard that there's a setting conflict with council, and I think I heard Thursday and Friday were also conflicted out for the staff. And then I'm out for 2 weeks, so we need to get as much done as we can when we can.
Okay.
Okay.
It looks like everybody's frozen on my end it looks like y'all are all frozen, beginning to move now, but
We can hear you, Judge.
okay.
Yeah, we can still hear
Okay,
you.
well
Okay.
then let's roll on through, see if we can get the judgment signed at least.
Okay. So I could not understand what you were saying about the child support section.
Okay. I think that what I was saying is that if that language were to be removed, as Ms. Eggleston is suggesting, it would not diminish his opportunity or his rights to receive payments for medical or extracurricular or other matters that might have been pronounced and ruled upon.
Okay.
Is that correct?
That's my understanding, Judge.
And I don't see the screen share up here, so here we go. Okay. I see it now. Okay.
All right.
Well, Miss Marglione, does that create some kind of problem for going
I don't think
forward?
so. I think we're all right.
Okay. Okay. Let's go to the next then, please.
All right. Okay. And then she also wanted to add that both parties have the independent right to apply for the passports for the children, but given that he was named managing conservator with exclusive rights, I left it is that he would have exclusive right for that.
And Judge, our position is just that there was nothing in the ruling specifically about passports. I understand that you did order exclusive rights, but oftentimes the passport provision is carved out and handled differently. I don't see a reason why she wouldn't be allowed to also apply for a passport in order to travel internationally with a child. I don't think there's any type of concern about abduction in this case.
Abduction, no, but there were some issues unless I'm confusing things. But I believe that there were some issues. I mean, we did bring up passports during the trial. And I thought that there were some issues with him being able to, he wanted to travel with the kids, and if I remember correctly, and he was unable to do so without her cooperation.
Well, and I don't think doing independent or exclusive here has any bearing on that. But
If we take out independent and exclusive, and this is saying that the father has the right to apply for, to renew, and to maintain possession of the passports. That doesn't deprive him of anything, and it allows for the prospect that she might apply, but that he is still the possessory conservator, or the managing conservator. And so if there was a desire to take them out of the country, it would have to be cleared with him, even though she might have the passport. I'm misunderstanding how that would work in reality.
yeah, yes, Judge, she wouldn't have to get his permission to travel internationally with the child if she has the child during her period of possession and she has possession of the passport. Either parent is able to travel with the child where they want to. There was nothing in the ruling that would prohibit that. So my proposal is that it's independent in both under dad's rights and under mom's rights, requiring both of them to sign off on a passport, and both of them are allowed to travel internationally with the child. There's not been any limitation on that.
I think it was be a good idea to include, so like I always include at the end of the orders, the Exhibit A and Exhibit B, basically, giving permission and all of that.
So I'm not sure I fully understand what that means. Ms. Marglione, if the word exclusive is removed, then is there the concern that she might take the children out of the country without knowledge or permission or consent from him?
Not that I'm aware of. I mean, and especially because I've included in this order the notices that they need to provide to each other, and in pretty extensive passport language, per the family code manual, or the family manual. So I think we'll be all right if we just remove the word exclusive.
Okay, let's do that. Okay, next issue.
Are we not adding the word independent? We're just...
That's correct.
Okay. And so we're putting that he has the right and she has the right?
I don't see that in the draft as it's currently written here in front of me.
That's how it is written in the draft in front of you.
That each of them has the right to apply for?
Right now, it just says he
Or is that
does.
simply
Well,
right?
Right there.
Right. It's in his column that he has the right to do that. It is not in her column.
It's in hers, Judge. It's right there.
This is what Miss Eggleston had inserted in there, but so I'm fine with. I believe it does not belong there.
And if it's silent and we don't give him the exclusive right, then the way it plays out is they're going to require both parents' signature to get a passport.
All right. I think that's the
We lost you there, Judge.
position. Just- I think that what we do is we eliminate would accomplish what I believe is in the best interest.
We lost you there. Can you repeat that?
I think that
Judge? Judge? I think we lost him.
I apologize.
Chat.
This connection is just a mess. What I was saying is that we leave the provision in the father's category without the word exclusive, and we eliminate the reference entirely with regard to the mother's provision.
Okay.
Okay, I don't know if there's something next coming up. I see the decree being scrolled on.
Okay. So the next part here is we're on page 13. So for Father's Day, I inserted basically whether they live, within 50 miles of each other or more than 50 miles of each other. So that was something that I felt it was important to include, particularly given that Ms. Zarate was talking about moving to Houston. So
I'm going to object to all that at this point and just look strictly at the ruling. And for holiday provisions, it's regardless of distance. So I don't know why in Mother's Day and Father's Day, we would delineate regarding how far apart from one another they live. And in all of the other holidays, not. That's not standard Texas Family Law Practice Manual language, and it wasn't part of the ruling, and everything in red should be deleted.
And I would say this is now part of the newer part of the family code, and the language is from the Texas Family Law Practice Manual.
And tell me again the age of these two boys.
11 and
9.
And 9.
Then I think this language stays.
But Judge, we're going to leave all the other language for all the other holidays and only differentiate for Father's Day and Mother's Day.
Well, that's all that I see.
I apologize.
That the concerns.
Sorry, Judge, can you repeat that?
I just stopped. It would seem to me that the distance is the concern with regard to any of these things. Father's Day and Mother's Day are just weekends. I guess Thanksgiving, Christmas, and school holidays are somewhat different, but it seems to me that the mileage restriction would be in the best interest of the children.
Okay. The next part is basically the return of the child. And so we're basically stating that that Ms. Bell Zarate should return the child to Mr. Zarate at the end of each period of possession. And then basically, if they're not in school, to his residence.
And I think the ruling was silent as to this. So my preferred language would be that you go get the kiddo when it's your time to get the kiddo versus my client being obligated to deliver the child to dad and then go get the child from dad.
Well, I think that Ms. Marcoleone's draft is the preferred draft from my perspective.
Okay. All right. The next provision is RS. Basically, we suggested that the parties use our family wizard to reimburse each other for expenses for the children. And I just think that this is so much easier and better and more just so much easier for the parties.
And I can appreciate that my client probably has a position about a lot of changes that should be made or things that should be added, but it wasn't ruled on. It can't be in the order.
That I cannot make decisions about the best interest of the children having communication with their parents.
This is just for basically how the parties should. Sorry, we're on it's how the parties should reimburse each other for expenses for the children. And so basically, I'm just trying to prevent a lot of headache that I've experienced in other cases.
And I can appreciate that. But again, Judge, I didn't go in and add a bunch of things that I think would be beneficial for these parties because it's not appropriate. It wasn't ruled on, so it shouldn't be included just because opposing counsel thinks that it would benefit the parties.
Well, if it's not included, then it's just left to just whatever somebody decides they want to do when they want to do it.
No, Judge, this is only about using our family wizard pay. So I want to make sure that we're all on the same page, and that it's just the one sentence that's currently highlighted in purple that Josie agrees was not part of your ruling, but wants included because she thinks it would benefit the parties.
However, you did order our family wizard, that the parties communicate through our family wizard.
And so, Ms. Eggleston, what's the downside to using our family wizard payment?
I'm not saying that there is a downside, Judge, but again, I'm not here to argue the case. I'm here to make sure that the order entered reflects the ruling that was submitted by the court.
I'll leave the provision in the best interest of the children.
Okay. Okay, the next section is electronic communication. The first section, I'm just going to make this a little bit bigger if I can. The first section was, so bottom section was my language, which followed the judge's, your order, specifically including text message and stuff like that. Their provision was similar. I think it just didn't include all of the, some of the things that you had put in there. And I did, from my original language, I did put in there that basically they shall provide each other with the phone, email, and other electronic communication access of the children within 5 days. She suggested 24 hours, so I'm good with that.
All right. Ms. Eggleston, do you have something that you need me to consider?
I do. She said that the language pretty much tracks, and I don't believe that that's accurate. The proposed language that she had also said telephone calls and other communications shall not be monitored by the other parent unless either believes in good faith that a child is having a problem, in which case the parent shall advise the other parent that the call or other communication is being monitored. That was not part of the ruling and I think should be taken out. If we're agreeing to change it to 24 hours from 5 days, then I don't have an issue with the rest of the language, but I would request that the sentence that I just read be deleted.
Well, I'm sorry. I believe again that it's in the best interest of the children that there not be monitoring, but unless there's a good faith belief that there's something injurious. And so that language can be included.
Even though it wasn't in your ruling, Judge?
Obviously I didn't speak to 40 pages worth of language. I'm going from the standpoint of making a factual determination about what's in the best interest of the children. And I know if you had been there, you might have said something to me about that at the time. And I appreciate that you're in the tough seat of saying, I got brought into this. I'm trying to get it clean, but I think that it's in the children's best interest to allow that provision.
Okay. Next section, other parenting plan provisions. So educational expenses. All right. So basically, so you stated that the parties would split 50-50 on medical insurance and extracurricular expenses. And so basically the extracurricular expenses, I have that in here. I also had educational expenses, assuming that was part of but I don't know what your thoughts were on that.
And again, Judge, I think that extracurricular and educational are completely separate expenses, and were addressed as such. Your ruling said that there was going to be reimbursement for health insurance and that extracurricular activities were going to be split 50-50. You did not say that educational expenses were going to be split 50-50.
And educational expenses, if the children go to public school, would be of what magnitude or what character?
Not very much, and that was where he requested that they go to public school.
Well, Judge, and I don't have that answer, because I didn't see testimony about it in the transcript. I didn't see language about it in the ruling, and I'm not really in a position now to try to enter evidence as far as that's concerned. It wasn't part of the ruling, and to ask for it now is a huge overreach, Judge.
I'm not sure that it's an overreach. I mean, as far as there's no child support.
If we're talking about these kind of what I see in the lingo here is class trips, activity fees, book fees, and fees for AP classes.
None of which was in your ruling, Judge. None of that language, none of that was addressed at all. And to include—
I understand, Ms. Eggleston, I understand, but the reality of it is the children are going to be going to school and there are going to be expenses, and these two parents need to share those expenses. What's next?
And then also on both of those, I have that these educational expenses, extracurricular expenses will be considered child support and are enforceable as child support.
Right.
I'm sorry, I couldn't hear you there, Judge.
I agree with that.
Okay. Okay. There is, Ms. Eggleston wanted a basically a non-interference with possession paragraph in here. Ultimately, I don't have that big of a issue with that, but I don't think it's necessary. I hope it's not necessary.
Okay, well then I'm not hearing strong pushback. So if it's superfluous or unnecessary or objectionable, then it need not be in the decree.
I think it should be. It's some standard language that basically says that it protects both parents from the other parent interfering with their period of possession.
And I mean, I think it's all understood in.
Okay, well,
I don't think anything is understood. I don't think
I think these people at this stage in their lives, and hopefully not for much longer, are at the potential tipping point where they might get a little bit out of line, and so that language I think is helpful, and we'll leave that in.
Where'd that go? Hang on. Sorry. Oh, where is it going?
How much more of this have we got? Because we're really running out of time here.
We're on page
Okay.
19 of 36.
We're not going to get this done before 10 o'clock. It's by my clock, it's 9:57.
Yeah.
So when do we reconvene? Or do we just suspend today's hearing and look for another date in the not too distant future? But recognizing that in the next 2 weeks, I'll be out of pocket.
I'm
Could Paige
available
be
at 1.
available at 12:30 or today maybe until we start our hearings at 2.
I am.
I'm afraid if we start at 1, we'll be going too close to when our other hearings are starting, but maybe 12:30.
12:30 works for me.
Okay, we'll try for 12:30. I don't have
Judge,
total.
could I have just a second? I apologize. I've got other things set too, but if you can give me 30 seconds, I can see if someone else can cover for me.
Well, I can give you 30 seconds, sure. Tell you what, why don't we do this? Why don't we, because it's a medical situation and I don't know how long that's going to have us indisposed. How about we tentatively at this moment say 12:30 reconvene, but if something is not workable, you communicate that with Miss Seeger. I'll try my best to make myself available at 12:30, again, contingent on the medical component of it. And if for one reason or another 12:30 doesn't work in somebody's column, then y'all let Miss Seeger know and we won't convene. If 12:30 is within the realm, I'll do everything within my control to be back here at 12:30.
That works for me.
Okay. So we'll stand in recess until 12:30 or until a future date to be determined. And I appreciate your patience and your understanding, and I apologize for the lack of facility here, but that's both technological and psychological. So anything of an informal off-record nature before we get back into the formality on record?
Not that I'm aware of.
All right. Well, thank you for your understanding and your patience. The medical situation had to be met, but fortunately everything's okay. So at this point, we're going back on record following a recess. We've got an hour in which to conclude the remainder of the matter based on the 2 o'clock docket coming in behind us. So if you're able to screen share where we left off, we can resume unless you all have something other than that you want to proceed with. We have a visual here.
And
Ms.
Josie,
Markley, on your
based on, I'm so sorry, based on the judge's rulings earlier, we can agree to the language under child support.
Okay.
So
All right.
including the withholding and change of employment. Yes, perfect.
Okay. Okay. So then we're good on the, Your Honor, at the time of the hearing, my client did not have health insurance. But just making sure, yeah. He has obtained health insurance and we have calculated that to be $160 for the children per month. So I put that in for reimbursing.
And Josie, you said that he didn't at the time of the hearing. When did it
Correct.
become effective and do you have proof of cost?
So I have proof of cost, but it's a cost for all 3. When he obtained it, we talked through it and I boiled it down and got him to give me a cost for, just him versus the kids. And so this is how we have come down to this cost. So the let's see here. So here, I'm sorry. So actually, he's actually paying, so the 160 is half of the medical insurance premium for the children, because the total is over $400. And I can pull it up and I can give it to you, the proof, the certificate of insurance and stuff like that, and I'll get that to you.
But when did it go into effect? And do you have proof of cost just for the kids?
I do not have proof of cost just for the kids. I don't have that in front of me. But it went into effect shortly after the hearing. Let me see if the document he just sent has that information. Okay, it was issued September 1.
So then the start date shouldn't be August 1 since there was no coverage. And Judge, from the time that we sent our first red lines, we asked for a proof of cost, excuse me, and we haven't received it. It seems like a pretty simple thing to be able to provide. So at this point, the objection I have to putting a number in there is no one's seen a number.
And I understand that completely. And I expect you both as officers of the court to honor your obligations to opposing counsel as well as to your clients and to the court, able to produce that $160 for the children. That will be the number that's put in. If she produces something other than that or nothing at all, then that won't be in there. So again, I'm expecting you, if you're making a representation on the record in my presence and to opposing counsel, that's going to be accomplished, and failing to accomplish it carries the consequence of that paragraph being stricken or revised to meet the actual requirements.
Okay, so Judge, so just for clarification, then you're not going to sign off on this order until we've resolved that issue?
No, I'm going to sign off on the order, but if you all don't get that documentation to your satisfaction, you contact me and we modify the order. But I think that from my perspective, from the bench, and having presided over the 2-day trial, I think these people, these parents, need specificity and enforceability. And so we're going to put it in, but we can take it out if it ultimately turns out not to be accurate or appropriate.
Is there going to be a deadline for them turning it over, since we've been waiting for quite some time already?
That's between counsel.
Well, Judge,
Again, between you two as professionals to treat respect and confidence and all of those kinds of things. But if you're telling me you asked for it,
Judge, you're breaking up again.
1 month ago and you haven't received it, sorry. What I'm saying is that you owe each other candor and professionalism and honesty. Disturbing. If you asked for it a month ago and it has not yet arrived, that's less disturbing. So if I'm going to leave it to you, to Ms. Eggleston, to decide when the time limit has come or passed, and say, look, we were in front of you on October 22nd. Here it is, November 22nd. Still haven't gotten it. We need to modify it.
well, I since you lose plenary power in 30 days, I guess, we'll have to address it before then.
Well, I think I have the ability to make a modification. Maybe I'm incorrect on that, but if I lose jurisdiction, then yes, there'll be something that'll have to be accomplished. So if you're telling me hard fast 30 days before I lose jurisdiction, or before I would be able to modify, that's one thing we have to honor.
Okay. Okay, so then the next part here, basically, this is an obligation of her estate, and it does not terminate upon her death.
Based on the judge's rulings earlier, we'll agree to that.
Okay. Um, this inserting paying off. So we agree my client is to obtain the the health insurance or dental insurance, which he has done. But by paying all applicable fees required for the coverage, including but not limited to enrollment fees and premiums, seems contradictory to the to the order that says they have to split everything 50-50. That I was just a little confused by that because I don't usually see that language in there.
It's standard language. If you want to take it out, we can take it out.
Well, if there's no objection to it being removed, then let's remove it.
Okay. Next part is dental support. I'll change this to September.
Judge, for the record, I'm just going to reiterate my objection to putting a dollar amount in the order when we've got no proof of the dollar amount, but it's going to be enforceable against my client starting today.
And if there is a lack of documentation within a reasonable period of time, or the documentation does not support that amount, I will certainly make the modification in order that it not be paid or that it be refunded or whatever seems fair and equitable under the totality of the circumstances.
Okay, the no credit for informal payments, support as obligation of estate, termination of orders on remarriage, but not on death. Those are all.
That can all stay.
Okay. Okay, so then this was just basically this probably is applicable like the other finding at the very beginning, but basically just stating that good practice to state that it's the reimbursement claim was denied, but it's resolved the other way. But if anyway, I figured it was good practice to state that.
And I think it's in line with the findings on, I believe it was page 2 that we addressed earlier this morning, and it should just come out.
And to be consistent, I think that's my view of it, is the fewer words in the decree than fewer than necessary are only necessary. Fewer than required.
Judge, sorry, you're breaking up again. Can you perhaps try turning your video off again? You're frozen, it looks like.
My philosophy towards orders is the less said, the better. What's required is required, but if it's not in there, then it's just not in there, and you don't need to say that it's not in there.
Okay. Okay, next section is property. So basically, I put in here, so this, okay, so what it said, okay, so I had in here 45% of the community property to be determined after the sale of the marital residence. See the sale of residence section on pages 32 to 34 below. And then again, so basically household subject to the provisions of the sale of residence, subject for like all the household furniture, furnishings, etc. And then except for the personal effects awarded to respondent in retrieval of property section below. all clothing, jewelry, and other personal effects in her possession. And again, everything is subject to the sale of residence section below. And then we've got she gets the 2013 Chevy Suburban in her possession and the 2022 Chevy Tahoe. And then we've added the bank accounts, again, subject to those provisions. And I think we probably need to address kind of like as a whole, the whole thing. So I'm going to keep going unless there's unless you have anybody has any comments or doesn't want me to. Okay.
However the judge prefers, I can respond to this section now or as a whole later.
I'm going to let you all direct that.
Okay. So same thing, property to husband, basically 55% of the marital residence, subject, 55% of the community property to be determined after the sale of the marital residence. Same as wife. So I'll have the subject to the sale of residence section, furniture, furnishings, all clothing. Okay, clothing and other personal effects in the possession of respondent husband are subject to his control, including the personal effects awarded to respondent in retrieval of property section below.
You're going really fast because that's what we do when we read.
Sorry.
Fingers do have some ability to go fast, but they can't run a marathon if you're with us on that.
Sorry about that. All right. And then his Ford F-450 vehicle, the go-karts, the prime flooring installation, which was the business, and then bank accounts. And I think all right, and then I'll just continue with the debt section. So basically, again, so all debts listed in the provision of sale of residence section below. To wife, the vehicle, the Chevy Tahoe in her possession, the debts in her possession. She specified she had a Chase credit card and a USAA credit card, but didn't tell us any balance on them. And then debts incurred from time of separation, which was March 10th, 2024. And then anything that was given to her unless otherwise stated in this. For debts for husband, again, all debts listed in the sale of residence. Debts from date of separation, encumbrances, and then debts associated with the business that was awarded to him. Okay, so then we get to the sale of residence part. So basically we stated that the property was to be listed with Mary Rodriguez. Sale price, that's not disputed. The make ready repairs and upkeep, they wanted to delete this section. I used what was in the transcript. Said the party shall follow all reasonable recommendations of realtor as to adjustments or listing or other recommendations for sale. The party shall split the costs of make-ready repairs and upkeep as follows: 45% by Anwar Zarate Martinez and 55% to Latoya Shaban Bell Zarate. If the vendor accepts payment at time of closing, the cost shall be paid out prior to distribution of the parties. If Anwar Zarate Martinez pays the full cost, and he shall be reimbursed at the time of the closing as described below. All right. Do we want to address at least this section right now?
I'd rather we go in order.
Okay. All right. Move out and retrieval. So the part that's crossed out was the part that was Ms. Eggleston's part here, and then the rest of this is what I had. So, which again, I was following the transcript. Latoya Shaban Bell Zarate shall vacate the house and property by the deadline assigned by the realtor, which is expected to be less than 30 days from the signing of this order. Upon move out, the property shall be cleaned so as to make the property presentable for showings. While still living in the property, she shall at times keep the house in good condition and clean so as to make the property presentable for showing by a realtor at any time. No utility shall be turned off or canceled prior to closing. Once
again, once again.
Sorry. Okay.
Sorry, Judge, I didn't hear that.
He's telling me I'm going too fast.
It's great.
Sorry.
Composition speed to read it, the document. You've both seen it. You both know where you're coming from, or at least the parameters of where you're coming from. And so unless and until I hear something that says that's objectionable or that's agreeable, it's what it is. If that makes any sense to you, just that these sections are in dispute. And if there is a concession that that's fine, then it's in. If there's a objection to it, I'll expect to hear the objection.
Okay. Okay, so so I believe okay, that paragraph, I believe there was an objection to this paragraph on the move out.
You're asking if I'm objecting to that?
Yes.
Yes.
Well, at some point,
Sorry, Judge, didn't hear that.
hear from you that we have no objection to that, or we do have this objection. I need to hear at some point that we have no objection to these provisions. We do object to those provisions.
Got an objection to all.
I'm sorry, say that again. Ms. Eggleston.
I've got an objection to all of it.
All right, let's hear the objection.
Do you want me to start now from the top?
Yeah.
Judge, we can't hear you.
Take it paragraph by paragraph. If you need to take it paragraph.
Judge, you're breaking up again, sorry.
We lost him, so hopefully he'll join back soon.
2,000 years later.
Judge Shulock called. He's having trouble with even trying to get some audio, but he's going to totally shut down his computer and log back in and see if that will help us get through this. I apologize.
No worries.
Technology is not always the best.
We've all been there.
Even when we're in the courtroom sometimes.
Yeah, that's true.
But anyway, he's going to try to come back on shortly, so we'll see what happens.
All right. Thank you.
Well, now wait just a minute.
Now I hear you.
There suddenly, okay, I'm going to shut off the phone. Okay. I've got a visual of Miss Marglione, and I've got a visual of Mr. Martinez, and I've got myself, and there, okay, I see now Miss Arate, now I see Miss Simon, now I see Miss Eggleston. I'm sorry about the pronunciation. And I've shut down about 4 different times and had, I don't guess the gods of the unit of the internet have decided that this guy's too old to know what the hell he's doing. And so let's just see if we can disturb him even worse than he's already disturbed. I'm sorry. I am very frustrated, very disappointed. We can continue to try to move forward as much as we can accomplish, recognizing that it's almost 1:30 and that they have a 2 o'clock docket. But if you all have conferred and narrowed issues and say these are the only live ones left, and maybe we can get some of that knocked out. And all of you are muted at this point. Oh, now you're okay. So I'm going to hide my video, thinking that might help. And if the rest of you will mute yourself except when it's speaking, we'll see if this will get us any further. I do have the visual again, the screen sharing. So let's see where we are, please. Thank you.
Ms. Eggleston, I think you were in the middle of saying something.
I was just saying that if the judge was wanting a response, judge, for clarification, all the things that Josie was addressing are issues that we have. So all of those things still need to be addressed. I'm happy to start, about 4.5 pages back, I think is where we were.
I wonder, let me ask this of you, counsel, and please feel free to be as completely candid and forthcoming as you choose to be. It will not offend me. I'm wondering if the now somewhat revised proposed decree with the red lines or the blue lines and the commentary might be resubmitted in a written format. And maybe I can look at them in a written format and then say to you all, I've seen where your disagreements and disputes are. I've resolved the ones, maybe all of them, or maybe some of them are still in need of oral advocacy. But does that offer any realistic prospects for you all to get this done?
I would say at least as far as the property division, I think there needs to be a little bit of discussion. I think it would help immensely to have a little bit of discussion on that.
Okay. And so that's where I guess we were when everything went awry. Ms. Eggleston, you were about to tell me about why this is problematic from your client's standpoint.
Yes, Judge. And I do think that some of the issues fall into a few categories that can be resolved, maybe with you giving us some clarification. And Josie, you feel free to let me know afterwards if I got it totally wrong. But Judge, in your ruling, you said that you were going to split the community estate 55% to husband, 45% to wife. The issue with that is you also said that the debts from the community estate were going to be paid off with the funds from the sale of the marital residence, and then the residence would be split 55-45 as well. The issue with that is twofold. One, I don't know how we're going to split the community estate 55-45 if we don't have a ruling on what is included in the community estate. The way that opposing counsel has drafted the order is basically that we have to take everything into consideration. Generally speaking, everything that they own, all of their debt, figure out what the house sells for. And at that point, we then have to divide the estate. I've got several issues with that. Again, one, we don't know what the entire community estate looks like. Two, that really prevents these parties from being able to divide their assets and move on until the sale of the house. And as I'm sure you're aware, Judge, Not a lot of houses are selling at the moment. Hopefully that changes here in the next few months, but there's a possibility this house will sit on the market for quite some time. And to keep these parties in limbo, I don't think is fair. My thought is that your ruling was intended that it's going to be we're splitting the house 55-45, because then you said who gets certain other assets. And so maybe if we can start by getting some clarification there.
Well, I think if I'm remembering, hearing you say that, the other stuff, I think in my mind, I was thinking about, the personal items that they recognize or can come to recognize, or that's not really part of the community, or it is community, but it's of more value and more interest to you than it is to me. And so take it and be done with it. But maybe that's hoping for too much, and maybe that's an incorrect view.
Well, Judge, and my proposal would be to, instead of saying that one party gets a percentage of the community property, which is not clear, not enforceable, and will lead to further litigation, my proposal would be in the decree to put who gets what. So if one party gets 45% of the house, then we put 45% of the proceeds from the sale of the marital residence, subject to the sale of residence language below. Then we say wife gets stuff in her possession and her personal property and her car. And same for husband, that he gets the business he was awarded, 55% of the proceeds from the sale of the residence, household furnishings in his possession. And you did allow, there is some language that we'll have to address the language itself, but about husband going and retrieving some personal property. So if it was your intent to basically have them keep their things and then split the proceeds from the marital residence 55-45, I think that will answer a few of these questions.
I will mostly agree with most of that. Like I said, as far as like the personal stuff, I mean, so the reason I said the personal stuff was subject to the provisions below was because my client needed to, and still needs to, be able to get the business property that is on the real property that's at the house. It's like, it's next to the house, it's on the property. And he hasn't been able to do that. And so that was basically, I mean, that otherwise most of the personal stuff, they were I mean, most of it they split. The only other thing he wanted was some furniture that he made.
Well, and with those things, I'm happy to address that too. But Josie, are you saying that you agree that, for instance, W1 on here should say 45% of the proceeds from the sale of the marital residence subject to sale of residence below?
So I don't know. I mean, basically, we don't have any evidence that has, with the balance of any of her accounts, any of her credit cards. She didn't give any evidence when I asked her about the value of her vehicle.
I'm going to object to, I mean, at this point, we've got a ruling, and that ruling, we're trying to get it into an order. So saying what she refused to do during the course of litigation after trial, I don't know that that's
no. I'm talking about what happened during trial. During trial, I'm saying she did not provide any evidence of the value of her vehicle or the loan amount on her vehicle. And so basically I left the vehicle and the loan in her column, as opposed to, because with no value, I left those there. But the debts that I did specify in the order, the debts that, because Judge, you did say that the debts would be paid from the marital residence, and there were, and those are the debts that we had specified in our spreadsheet, and those you also specified in your ruling, like the tax debt, the all the make ready stuff, the
And again,
loans.
I think addressing all of these issues in 4.5 pages as a whole is going to be confusing. I think if we start with what the judge's intention was in the ruling on the 45-55 split, then we can at least have a baseline and go from there. Judge, did we lose you?
No, I'm here. I'm trying to process, trying to get my head around the dynamic of the disagreement. In the particulars of it, you all seem to be in agreement about the proceeds from the sale of the property.
I don't think we are, Judge.
All right. And so what is the disagreement about the 55-45 split from the sale of the community assets?
Because the way that you ruled was you said that we're going to sell the house, we're going to pay off all the debts, and then we're going to look at what's left and we're going to split everything 55-45 is basically the way that I understood what you orally rendered. And I think that Josie would agree that that's what the transcript says.
Yes.
I think that if that lands in an order, we're going to have to redo the case because there's no way for us to be able to effectuate that after today. Especially if Josie is saying that my client didn't enter evidence about certain credit card statements or how much it was owed on the vehicle, then there was no evidence entered as to what all of the debt was. So how can we determine what gets paid and who lands with what? My proposal would be that we do something here that is enforceable, and hopefully with the intent of the court being that as far as the house itself is concerned, we're doing a 55-45 split.
Well, in other cases, and maybe this is a fevered dream of mine, if the parties disagree about the value of their collective estate, then they get an independent appraiser. They get somebody, and I realize that takes time, that takes money, and that takes, away from values perhaps, but it is what it is. You've got some stuff that's got some value, and the question is, well, what is the value of the stuff? And so if the parties can't agree to the value of the stuff and then to split it 55-45, then you've either got to litigate that, which the case has been disposed of, sort of, or at least that part is still hanging in the balance, or you get your heads together and lawyer to lawyer negotiate and advocate and advise your clients and say, look, this stuff, this property is worth somewhere in the neighborhood of X. And so if you can agree that it's X, we'll split it 55-45. If you can't agree that it's X, then we have to find some neutral who will do the evaluation and we'll live and die with that.
And Judge, I would argue that that isn't an appropriate ruling after the trial is over. That that should have been done before the case went to trial. And I'm not pointing fingers at who did what.
But nobody did it. So
Judge, you can't rule that the parties now have to go figure out the value of things because that's part of what your ruling needed to entail was what is part of the community estate, what the values are, and who gets what.
It wasn't put before me. I don't try stuff of my desire. I let the lawyers and the parties present their case on the evidence that they want me to consider. The fact that they didn't put it on doesn't mean that I have to decide it. I just say 55-45. If y'all can agree to the number, y'all agree. If you can't, then you've got to get somebody to decide what the value is. But we didn't have a trial that included the value because nobody offered that evidence to me.
Well, and Judge, again, after we deal with the motion to enter, I've got a motion to set aside on the board. And if the trial wasn't done appropriately and we don't have values for the community estate and we don't have lined out what was part of the community estate, I think it only makes sense then to turn around and retry it. I think to say that we're going to figure it out on our own after this, I don't think that's a reasonable expectation. And I think that's probably clear based on what you saw at trial, Judge. And the parties would have to turn around and either agree on experts to determine values for things or have competing experts, but you're basically signing a decree that doesn't divide the estate and leaving the parties in limbo. It doesn't benefit either one of them to handle it this way, because then we've got a mandamus and redo it months from now.
And I would disagree a little bit, because I would say that, we did provide a property spreadsheet that had values, at least as far as the information for my client. And I have also, there's case law that says that if a person didn't provide a value, then it has no value. I mean, basically, if they didn't provide evidence as to value, then it has no value to divide. So, I mean, basically, my suggestion is we go with what has been, presented and what evidence we had.
Again, and that's another problem then, Judge, is that part of your ruling said that we're going to pay off debt, but in Josie's proposal, anything my client didn't do properly, we're not even going to consider, and we're not going to pay off that debt either. So basically, not only does he get a disproportionate share of the sale of the marital residence, her car debt's not taken into consideration, her credit card debt's not taken into consideration when dividing the estate. So she's going to be tasked with being responsible for those debts, but not get any credit for that on a hypothetical spreadsheet. And on top of that, when the community estate debt is paid with funds from the sale of the marital residence, my client's stuff isn't going to get paid. It gives him such a disproportionate share. I mean, you're looking at closer to 70%.
So I would just
wait. Let me speak.
Sure. Yeah.
Case was called for trial. Parties announced ready for trial. Parties were given the opportunity to put on the evidence that they wanted me to consider. Parties put on evidence, and what they didn't put on is not my problem. It's their problem. And so if I say there's going to be a split of 55-45, it's based on what was presented before me. And so if there's an ongoing dispute about, well, this could have been or should have been included, then yes, you're going to either have time and money and effort spent on a retrial, which I don't think is going to happen. You're going to have time, money spent on an appeal, which I don't know the result of the appeal would be. You're going to have time and money spent on an appraiser or appraisers, or you as counsel for the parties now both being represented are going to be able to accumulate the information from your client's perspective, share it with your opposing party, and see whether or not that's an acceptable, agreeable, or not. And if it's not, then maybe we have something to talk about. But in the meantime, it's all about taking time, taking money, taking effort, and with uncertain odds. And it's unfortunate that the case was tried the way it was tried, but it was tried the way it was tried. I follow rules of procedure. I follow rules of evidence. And what was brought before me, I considered, and what wasn't brought before me, I couldn't consider. And I can't come back at a later time and say, well, let's have a second trial. Let's do something. Y'all didn't put on enough evidence, so let me get you to put some more evidence on.
Judge, just briefly, the parties are not going to be able to come to agreements on all of this stuff, first of all. Something as simple as obtaining cost of health insurance. Our first request went to opposing counsel on August 21st. We still don't have it.
August 21st, okay.
To think that we are going to be able to sit down and now figure out what is part of the community estate, agree on values, and agree to disposition within 30 days is not possible. And outside 30 days, you lose plenary power and they're stuck with this order that's not going to be enforceable, that doesn't divide their estate. It doesn't even specify what their estate looks like. And the opportunity for there's not going to be a point where they're ever going to be able to co-parent if we're still dealing with pots and pans for the next 6 to 8 months.
And whose fault is that?
Judge, I don't have an answer as to whose fault something was. I can tell you that if your ruling is 55-45, the entire state, then we need some clarification on what is part of the community estate.
And how am I going to make that determination? The evidence is closed. And even if the evidence had been presented, it would be my decision. And so, yes, but the evidence is closed. So there was no evidence about it's worth, on your client's side of the scale, it's worth 1,000. On his side of the scale, it's worth 16,000. There's no way for me to decide what that number is, whether one's right, the other's right, or it's somewhere in between. It's beyond my ability.
But you have the option to reopen evidence and allow
I'm not
us.
going to reopen evidence. We had a trial. We had a 2-day trial that was supposed to be a 1-day trial. The fact that evidence wasn't presented is not my responsibility.
So is your ruling that the parties are to figure out what is part of the community estate, sell the house, pay off all the debt, and then split the estate 55-45?
I believe that that's what I was ruling. I don't know, maybe Ms. Marglione heard it a different way, but I believe that's what I was ruling.
Yes.
So these parties aren't going to be able to split their assets until we have an agreement on what the community estate entails, what the values of everything are, and the house sells.
At some point, they're going to have to move on with their lives. At some point, they're going to have to cross this bridge. I didn't make the bridge. They made the bridge. So they have incentives, economic as well as emotional, to get this behind them and start the next chapter in their life and in the lives of their children. So one of them can dig the heels in, or they can both dig their heels in and say, we ain't agreeing to anything. Or they can say, look, if we want to divide up property and know what's mine and what's yours, we have to work together. And now we both have professionals who can advise us and who can advocate for us. And if you can't come to agreements, then maybe you go to a mediation. Maybe you go to a mediator and say, we think it's worth 16,000. They think it's worth 100,000. Mediator, help us get this decided. Help us reach some kind of accommodation.
And when they don't, this order is not going to be enforceable, Judge.
No, it is enforceable. It says 55-45 of their property.
But we don't even know what their property is or what the values are. It's not enforceable, Judge.
Their property is their property. It's a legal matter. Counsel, it is. They either own it or they don't own it. Now,
we're talking
how much
about
is
the
it worth?
community.
Counsel, they either own it or they don't own it, and they either agree to a value or they don't agree to a value. If they agree, you can split it 55-45. If they disagree, then you've got to get somebody to break that disagreement. But it's not coming back in for a new trial.
You're ruling now without having her. Okay.
The evidence is closed. The judgment is to reflect the decision of the court based on the evidence that was heard and found to be credible and persuasive and meet the burden of proof. That was not presented was not presented, and there's no way to decide or evaluate. It's getting very close to 2:00. Staff has been very helpful and is very much appreciated. And all of you are very much appreciated for your patience and your understanding with the technological problems that we've had and the scheduling problems that we've had. But we need to somehow get to an end point, or at least a pause point, and see what we do from here.
So I'm going to make a suggestion. So how about Ms. Eggleston and I confer a little bit on property, see if we can get closer, if not an agreement, and chat, and then basically send the remainder of the order to you, Judge.
I think at some point there has to be some specificity, and that can be achieved by agreement. And again, you've got competent counsel who can take advocates' positions and who can also predict or assess, I should say, prospects for some neutral to be making a decision about values. And on that basis, get it resolved, or go pursue some other remedy about that, which again, it's not my place to tell you how to run your railroad. But yes, if counsel can confer and can get clients to understand and accept and participate on an equitable basis and on an economic basis, that's all to the good. But to say what I said, which is their property is to be split on a 55-45 value or percentage, that is the judgment. The value is the open question, and you all don't get to reopen the evidence and say, well, let me put on my evidence of value and you put on your evidence of value and let the judge decide the value. That's water under the bridge. That didn't happen, and so it's got to happen in some other way at some other time. Hopefully sooner rather than later, and hopefully at less expense than more expense.
Judge, we've still got dozens of issues to address in the order, as well as the motion to set aside that we'll need to have a hearing on. How do you want to handle that?
Well, I think the motion to set aside, I view as a motion for new trial. As a matter of fact, I think it's styled a motion for new trial. I don't think a motion for new trial is ripe for consideration until a judgment has been signed.
It's styled a motion to set aside oral rendition, alternative motion to reconsider and to reopen evidence, and alternative amended motion for new trial.
Well,
But if
I've
you're
already
saying,
said I'm not going to reopen evidence.
are you not going to have a hearing on the motion?
That's correct. I've read the motion. I've seen and heard what the fight is about. I'm not going to reopen the case.
Have you read the amended motion or just the original?
I think that I read the amended.
And just for clarification on the record, you're refusing to have a hearing on it?
No, we're having the hearing on it. I'm denying it.
No, Judge, we haven't had a hearing on it. All that we've spent
This is a
today
hearing.
doing is a motion to enter. Well,
No.
I've not addressed my motion or any aspect of the motion at all.
All right, counsel, you are the expert in family law. You can make your strategy and you can pursue your course of conduct. I am not granting a motion for reconsideration. I am not granting a motion for new trial. I'm not granting a motion to reopen the evidence. Do you need something more specific and more clear than that?
Just needed clarification that the hearing was set, but you're refusing to have it, Judge.
I don't think the hearing was set, but I am not granting those motions.
Today, there was okay, understood, Judge. how are we going to reconvene to finish the motion to enter?
There was a proposal that perhaps there's some more common ground that could be plowed between council, and hopefully that would get it to be done. And I will give you the opportunity to do that for a reasonable period of time, but this does need to have a final decree signed and filed for specificity and for enforceability.
Agreed.
So if we can't come to an agreement on all the issues, what would you like for us to do, Judge?
Then you'd have to contact the staff and see about getting back on a calendar.
Or could we submit it in writing instead at this point?
Well, getting it on the calendar could be done by submission, yes.
I'm just so like I'm like our like we did earlier, basically here, basically these are the issues we still are in disagreement on, and then basically you make that decision, or because I know it's difficult to get us all in person at the same time. And so I'm just wondering if we can see if we can work out an agreement in a very short period of time. I would say very short period of time. And then basically we submit to you what is left. That's what I'm proposing anyway.
I can and I will decide as much as I can handle on a submission basis. If there is something that is beyond the ability to be considered fairly and efficiently on a submission basis, then we can talk about resetting some type of oral hearing.
Okay.
Or setting for an oral hearing.
Okay.
And it's an obvious statement, but none of us are getting any older, and one of us is not getting any smarter. So, if you want to try to, again, close the chapter, move on, then, that's the incentive that exists or ought to exist, because the children deserve it and the parents deserve it. They deserve to be able to say, okay, that is now over and done with. Now we're focusing on this. The things that are important are the children's health and well-being and education, as well as the parents. And that can happen through cooperation and conciliation, where conciliation is appropriate and necessary and fair. Or you can continue to dig your heels in and say, we are fighting to the death on this thing. I will never, ever surrender. I will never, ever give a point. I will always do something that I think would be harmful to the other. And that's just no way to live a life. And that's no way for the children to observe how adults behave. I'm sorry that I'm in the state of mind that I'm in. Some of it's due to the technological problems that we've had, but some of it is just in the fact that this could be done and should be done under more amicable, more efficient, more equitable kinds of circumstances. And I don't mean that as a criticism to anyone in particular. It's just my perception and my observations and communications to you, having sat on the bench and seen and heard a fair number of cases, and seeing the ones that seem to work themselves out to the most positive benefit for the parties, and seeing the ones that don't. So I will recess this hearing to see whether or not there are things that can be submitted in a submission format without an oral presentation that narrow or conclude the issues, and those that are not concluded may or may not be able to be heard, but we'll certainly do what we can consistent with rules of procedure, rules of evidence, and the duties of equity and economic efficiencies before we split off and go into our respective Coroners, is there anything else that you all need or want me to know?
Judge, I need to make an offer of proof. And it needs to be on the record.
And how much? It's 2:00. They've got a docket that they're entitled to hear. We're squeezing in on their time. If you've got something that you need to submit that's evidentiary, perhaps that can be accomplished in a written submission.
No, Judge, this is for to firm up my appeal. I have to put this on the record. It's an offer of proof due to you denying the motion to set aside and to reopen evidence. I just need to orally put it on the record.
And how long is that going to take?
I can do it in 2 minutes.
Go.
Thank you, Judge. It's my understanding that the judge has summarily denied the motion to set aside oral rendition, denied the alternative motion to reconsider, and denied the motion to reopen evidence, as well as the motion for new trial. The judge summarily decided on these motions without having a hearing. If the judge had allowed us to reopen evidence, we would then would have called my client. I would have called opposing party, and the parties would have testified to the items that constitute the community estate, items that constitute the separate estate, any reimbursement claims that were on the board, as well as they would have testified as to the value of all of the debt and assets, thus effectuating an appropriate division of the estate.
And what discovery had been done as to those matters prior to the case being called today?
I'm finished with my offer of proof, Judge. Thank you.
I have a question to you, counsel. What discovery had been done on those matters that you just articulated prior to the case being called today?
I don't have that answer, Judge.
No discovery. You have nothing to offer that says this is the scope of what was going to be said. You are saying to me, let me go do some discovery and let me bring that discovery evidence to you.
That is not what I'm saying, Judge. I'm saying that had you granted these motions, we could have had a hearing and those things could have been presented.
Correctly, but you're saying it would require testimony from your client and testimony from opposing party.
Which is what would have happened if you had granted the motion.
And that would be an open-ended, let me just ask all the questions that I think are essential or relevant or even interesting regarding property values.
By putting my offer of proof on the record, I wasn't arguing with you. I understand what your ruling is and why you decided to make that ruling. The offer of proof is a procedural vehicle that had to be met in order to do things after today.
And I'm just trying to make sure that I understand what that offer of proof was.
That offer of proof was that in the event that you had reopened evidence, I would have called the parties to testify and fill in the holes regarding the assets and debt.
Even though there's been no discovery done into those issues by either party or either counsel.
Correct.
So you'd be doing your discovery in the courtroom in front of me.
No, Judge.
You just said you'd call them to testify to their values.
That's correct, Judge.
And so that would be in essence a discovery deposition conducted in the courtroom.
I can understand that that's your position.
Okay. All right. Well, I am going to then, unfortunately and regretfully, close this matter for today. Encourage counsel to communicate and negotiate and advocate and advise clients about the time, the money, the energy, and the emotion that is going to be encountered and incurred in the event that the parties are unable to make some accommodations, even if those accommodations are not totally what you want for your side of the case. The expense, the time, the effort are something that should be of some consequence and of some incentive. But that being said, I'm going to again, due to the lapse of time, taking more than we had budgeted for yet again on this matter, I'm going to conclude this proceeding, but not close the door to additional communications and additional requests after there's been some additional processing by counsel and clients. So we are adjourned for the day. Thank you.
Thank you, Judge.